Hello, everyone. Welcome to another episode of Rethinking Legal Ops. I'm Ashwarya, head of legal at Speed Legal. At Rethinking Legal Ops, we have forward-thinking conversations about how legal tech and artificial intelligence are transforming the way we practice law. And for today's episode, we have an amazing guest, an innovator in the legal industry, also an industry leader changing the way we approach contracts and practice law every day. Electra, so amazing to have you here. And I'll let you introduce yourself.
Thanks for having me. Hi, everyone. I'm Electra. I'm the founder of TLB, which is a legal design and legal operations consultancy. And I'm also the co-founder of ClauseStack, which is a legal community platform that focuses on standardization, and oneNDA, which is an initiative that we launched last year to create a single NDA that organizations adopt across the world as their own template.
That's amazing. And I've been following all your work, and I've got so many questions that I need to ask you about that over the podcast. And I'm sure our audience also have questions. So feel free to say hi and drop in your questions in the chat for Electra. So to start off, Electra, what has been your journey from in-house to innovator and now to oneNDA and CloudStack, changing the way we do contracts?
Yeah, so I started off my career in-house. And I started off working at the European Space Agency in the Netherlands. And then when I was in that industry, when I was in the space industry, standard contracts were the way that people did business. You won't really meet a space company that has their own terms. They all use ESA, the European Space Agency's standard terms, which makes business concluding contracts quite easy. And then, so I was in the space industry for about 4 years, and then I moved to a more commercial role at British American Tobacco, and then I moved over to Disney and then EY. And every organization that I worked in after the space industry, I did feel like there was huge inefficiency when it came to the way that in-house legal operated. And I also felt that there was a huge disconnect between in-house legal and the business, so speaking different languages, really. So the objective of TLB, which is the company that I set up in 2017, was to build a business that would effectively create a bridge between in-house legal and the business through better ways of working. And standardization wasn't really on the horizon for me at that time, but just to give an understanding of why I've always thought standardization was a good idea is because I've witnessed firsthand how efficient it is. So I started TLB, and TLB works with in-house counsel and continues to help them with their overflow of contracts that they have, and also to build better processes through technology and design. And then 2020 hit. And it was COVID, and it was the global pandemic, and no one was hiring for a while. So all the in-house teams that we knew were giving us more work because they weren't hiring anymore. And we were also getting more and more clients who needed a bit of support. And so at the end of 2020, we did a review of all the contracts that we'd looked at over the course of the year. We found that 63% of the agreements reviewed were NDAs, but that only accounted for 7% of our revenue. So it wasn't profitable, and it was a headache. And as an organization, our mission has always been to help streamline the way in-house legal works, and it felt like we were actually part of the problem. So I went on to LinkedIn and I said, why do we all have our own NDAs? Why are we using expensive lawyers to review contracts that no one really cares about? The ROI is minimal. They hardly ever get litigated. What's the point? Are we just dancing this dance? What's going on? And that post got a huge response. It got 35,000 views, which is big for me, at least. And then I said, okay, if we can get 100 people to sign up to this website that I set up over a weekend, we'll spearhead the initiative to standardize the NDA and create oneNDA. And we launched the website, and we hit 100 lawyers within 12 hours from launch. And within the 2-week period that I'd given as a deadline, we had 335 in-house lawyers that had signed up, and also law practice lawyers. And so, of course, we had to spearhead the initiative, which we did. And then we created oneNDA with a steering committee of loads of amazing lawyers from organizations like Google, AstraZeneca, EasyJet, Diageo, UBS, and also law firm lawyers from law firms like Freshfields. We had Linklaters, Slaughter and May, Ashurst, Gilbert and Tobin. So we had a bunch of superstars that were supporting this. And then as part of what we were doing, we were putting together this community of innovative lawyers across the world that really believed in standardization and were looking for a better way to work. And so by the end of the project, we actually had 10,000 people's emails, but this was an audience. So it was an audience, and we were broadcasting to this audience, and we thought there's clearly appetite for standardization, but also there's appetite for peer-to-peer collaboration and open source initiatives like this. So how could we get this community together, which is where ClauseStack comes in. So ClauseStack is a platform that we set up. We only launched it last month, and it's a legal community platform for lawyers to come together to collaborate to create more standards. And the first project is already live on ClauseStack, and it's oneDPA. And the objective for that is to create a data processing agreement that is standardized, because there's absolutely no reason for it to not be standard, considering that most of its content is driven by regulation and case law. So phase one of oneDPA is now finished, and now we're in the drafting phase. And we will be announcing the steering committee later on today, actually. So yeah, that's a background on me.
That's awesome. And yeah, really looking forward to also reading oneDPA, because I was reading oneNDA and that was just so amazing to see the sort of standardized document. It's also quite user-friendly, very easy to follow, not as much legalese, which leads me to my next question. Why is user-friendliness becoming more and more important in legal documents today? And is legalese a thing of the past, the way we are doing contracts today?
I hope so. Legalese is just nonsense, in my view. If you're a good lawyer and you know what you're talking about, you can say it in plain English. And if you think about it, legal documents are rarely for the use of lawyers. You draft a set of T's and C's, it's meant for a consumer. You draft a license agreement, it's meant for the buyer. You know, whatever it is that you draft, very rarely is the end user actually a lawyer. And yet lawyers don't always, we're not taught to consider the end user. So taking that customer first approach is what's going to make your document more user friendly, and in turn build trust, reduce disputes, because if the other person understands what you're asking of them, they're likelier to be able to comply. It breeds trust in your brand. So lots of organizations, particularly, you know, in the fintech space, for example, where your terms are in fact quite onerous often and complex, you can't be spending, you know, millions on your brand and neglecting your legal documents, because that's part of your brand, and that's the bit that's going to really make people trust what you're saying, because that's the crux of it. And of course, in-house lawyers are always overstretched, and they have, you know, they're under-resourced, and they're trying to do more with less, which is such a cliche phrase, but it's true. And so if you create documents that are user-friendly, you can actually empower other teams within your organization to take on some of the work that you're doing. So NDAs, there's no reason for a lawyer to be involved. They're super straightforward. If you write them in plain English, then there's no reason why your sales team can't just facilitate the whole NDA process. And in fact, during oneNDA, we polled the community and we asked them, who is the predominant user of NDAs within your organization? And 75% said the business. The lawyers don't touch them. So we couldn't create a document that was legalistic. It had to be plain English, and it had to be accessible.
That makes a lot of sense. And I remember from one of your other talks, you were, you know, comparing sort of NDAs to like a gesture. For example, like on a date, when someone brings you flowers, it's simply a gesture. It's not something that's going to get litigated or, you know, mean anything. And the best way to keep a secret is just not to share it. So it makes a lot of sense to not spend as much time and money and effort drafting NDAs, which is why I think what you're doing with oneNDA is truly amazing and very, very useful. And what you were saying about, documents or drafted contracts being brands to attorneys, I'm curious to hear your perspective about what's more important, having custom drafts that sort of reflect your brand as an attorney, as a law firm, or just more a sort of...
I've lost you.
Oh,
sorry, you froze there. I missed the last bit.
No, I was just asking, what's the relationship between, putting so much importance in sort of reflecting your brand with your drafts that you do with custom drafts, or just a more efficient standardized drafts like oneNDA?
Yeah, I mean, I think that, well, the way I envisage the future of contracts is that we all get into a position where we have a few standards that we agree are the standards for commoditized agreements, of course. And next time you enter into a negotiation, you just say what standards you accept. And say for an NDA, I accept one NDA. I also accept this NDA and this NDA. If you want to do business with me, choose one of those standards and send them to me and I'll sign it. I won't negotiate. That would make life so much easier. When it comes to your bespoke terms that are for your product that you can't really commoditize, I mean, you can potentially commoditize some of the clauses when the world progresses enough for us to have standardized clauses that represent a function, which we may get into later, but I think that's the ultimate sophistication of where standardization comes into play. But it would be amazing if you just said, hello, I'm Google. These are the 3 NDAs that I accept. And then another organization comes along that wants to do business with Google. They present them with that document. And as I started to say, if you've got a really bespoke set of T's and C's that you need to have because the nature of your product is so special, then of course you should take a lot of care in how you write them. So one of my favorite videos on YouTube is the one where there's a guy who reads out the T's and C's of Kindle. And I think it takes him 8 hours or something mental like that. So obviously the lawyers that wrote that didn't think that any consumer was actually going to read them. So we just need to be mindful of how that represents your product.
Yeah, super important point. And also, why do you think that there's just so much pressure on this sort of this artisanal approach to like contracts? Like you have said in your previous talks that not everything needs to be bespoke. There are a lot of documents that you could just save a ton of time on by making them easier, more accessible to users. Where do you think this sort of approach comes from? Is it just this willingness to maintain their own like unique brand? Like every law firm, it's a copyright to their own templates. So do you think it's just trying to distinguish themselves? Do you think it's the way we're taught law in school? What do you think it is?
I think it's a combination of all those things. We are taught that we need to be showing value as lawyers. And so when you get a document that contains words, you immediately get the red pen out and you start marking it up so that you can make it more clear, more concise, more to your style, more to your preference, so that you can show your client that you've added value, knowing full well that your client probably doesn't really know what the value is, but just seeing the changes, you might assume that your client now thinks that you've done something. When you look at an agreement, and this is a stat that we got from the World Commerce and Contracting, which is a non-profit organization that strives to create better ways of contracting. They gave us a statistic that I thought was really interesting, and that's that 90% of all agreements contain language that is boilerplate. So if you look at an agreement, you've got your entire agreement clause, you've got your severance, you've got your notices. Why on earth are they all different? And there's another tech company called Thought River, and they did a review of 347,000 agreements, and they found that one clause, I think it was the notices clause or the entire agreement clause, was expressed in 147,000 different ways. It says the same thing. It's so inefficient because you have this license to write it in any way that you want, I've got to review it. I've got to review it every single time, and I don't need to. I just want to know that it's the entire agreement clause that says this. I don't want to have to review every single word that you've used to express that provision. But lawyers, I think, law firms have been able to charge for the artisanal approach. So to an extent, standardization is arguably a conflict of interest for law firms. Although having said that, we're a legal services provider, and NDAs were not profitable for us. They were just a headache, which is why we spearheaded oneNDA. So some law firms, we had lots of law firms that were involved in oneNDA. They see the value of standardization. But in terms of why historically we're in the position that we're at, I think probably because law firms were able to charge for the artisanal and bespoke approach of everything, and also sort of keeping the keys and saying this is too special for it to be standardized or simplified. It has to be reviewed each time by me. Is something that gives us a sense of importance potentially, and also I think that lawyers do like to have license to mold and to treat contracts like they're a work of art. They're not a work of art. And you might feel when you've redlined the hell out of a document that it is a work of art. It's not. It's a business tool. And you need to think about whether you're happy to trade that artistic flair that you have over your contracts for better ways of working and slicker business operations. And I think that's a very real consideration, and we need to start thinking about it.
Yeah, I'm totally with you there. And when you were talking about contracts being work of arts and not, it was reminding me of a recent talk I attended at Stanford. There was a speaker from Ironclad, and they were talking about like lawyers like to treat contracts as works of art, but most of the time they're just a print.
Yeah. I like that. It's true.
Yeah, you create one and then you just keep reusing that. So yeah, absolutely with you. So with NDA, it's pretty clear that they were not really profitable to draft, or just as much of legal relevance, even because it cannot really be litigated, more of a gesture. But DPAs that hold more sort of importance and are very integral to businesses. What's your process in going about DPAs, just the same format that you were following for oneNDA as well, because the stakes are higher for this one?
Yeah. So oneNDA took 6 months. What we wanted to do with one DPA is scale the process and digitize it to the extent possible. So we are aiming to complete it in 6 weeks. So what we did initially is crowdsource opinions from the wider audience on which principles should go into one DPA and which should go out. So here what we try to do is separate the function of the clause from the drafting of the clause, because as lawyers what we do is we do 2 things with our brain, which is first assess whether we agree with the principle, and second, whether we like the drafting that's being used to express said principle. So we don't want people to get bogged down with the drafting. We just want to talk about, is this reasonable? Is this reasonable? Is it reasonable to say that you expect the processor to allow you to audit them whenever you want? No, that's going to be a contentious point. So let's just agree that that's not going to go in. So we set out all the principles on clause stack, and we got the wider clause stack community to come and vote on those. That process closed last week, and now we're in the process of drafting. So we have a drafting group, and with that drafting group, we're putting together a document that should be ready today, and then that document will go out to our steering committee, and they will assess it and see whether there's anything in there that's a glaring gap, or that's something that shouldn't be in there, that's obsolete, and that will be a barrier to them adopting it. Because what we want from our steering committee in this project is to adopt it, so that when we go to market with one DPA, we can say, and these guys have adopted it. So have faith that it's a good document, because these are big organizations, and if it's good enough for them, then it might be good enough for a smaller organization as well. So that's the objective. Then once they've reviewed the document and provided comments, we will iterate on those comments. And then on the 6th of May, we're going to issue the document for comments by the larger community. Then we'll take those comments and we'll iterate again, and then we'll reissue it as version 1 on the 27th of May. So that's the process. And the scope of one DPA is to cover as many jurisdictions as possible, with a particular focus on the UK, EU, US, and Australia.
Wonderful. And And when you're talking about, referring it to a steering committee and like having all of these experts look at a document, I think that's so cool because when someone looks at one DPA and when people are using one NDA, it's not just a document drafted by one attorney or like, two of their attorneys. It's some of like the best attorneys, the best innovators in the legal industries that you can find. And the fact that you're making it so accessible, I think it's really, really admirable. And Electra, when you were talking about, there were 147 ways in which like just a simple notices clause, just a routine clause was written, it also reminded me of the frustration that exists in a lot of like the legal tech industry that contracts, a lot of the clauses just can be standard, and we could use a lot of AI to just automate this, just a review process. And because of all these variations, that process gets impeded. So how do you see one DPA and one NDA also being a huge ally to other existing legal tech tools? And do you also have plans to maybe partner up with other legal tech tools to, maybe take one NDA and one DPA to the next level, and also start facilitating not just drafting the contracts, but reviewing them for businesses?
Yeah, I mean, I think AI is completely wasted in the legal industry at the moment, is my honest opinion. I think that we're using AI to decipher what a contract says. Whereas if we had consensus on what those elements are that make up a contract, then we could use AI to do smarter things like predict what the contract should include for the specific use case. So we could use AI to look at, how those clauses performed in other agreements, and like you're writing an email on Gmail and it tells you what, I hardly ever type out full sentences now. I just press tab. So if we could have that, if we could use AI to do that, that would be a massive game changer. But unfortunately, whilst we continue to use an artisanal approach, it will be very difficult for AI to do that, because you have to use up its energy to try and figure out whether this clause says this or that. So I see huge opportunity for AI, and I think that if anything, the AI legal tech companies should be the ones that are really driving this, because their utility will be so much greater once standardization is more mainstream. In terms of whether we plan to collaborate with tech companies, we already are. So one DPA is sponsored by ContractPod AI and PwC. And ContractPod AI, as the name says, is an AI CLM. But we also have agreements with around 100 other legal tech companies for one NDA, and they're facilitating one NDA for their clients and automating it. So yeah, absolutely. ClauseStack is a community platform, and the legal tech community is really important to us.
That's amazing. And I think at Speed Legal, we're particularly excited about what you're doing with that, because that is an issue that we deal with as well. So contract standardization, it's just exciting because it opens up so many possibilities. And often when people talk about standardization, they forget that there's a lot of creativity and innovation that goes into just standardizing. Because standardization is associated with, being like plain and, not as creative. But I just want to hear about the creative process that goes into creating one standard document, because standardization on its own, it sounds really cool. But can you talk about just the amount of work that goes into it? Like you said, it took 6 months to create one NDA, and getting all the lawyers to agree on one document is hard enough within one law firm. I can't imagine what it was like for you. So can you talk a little bit about that?
Yeah, we made it up as we went along. So I had a rough idea of how I thought the program should run, but we had to make it up as we went along because we'd never done it before. And then we did one NDA, then we did one NDA plus M&A to build a module that you can tag onto one NDA to make it fit for purpose for an M&A scenario. And then we did one DPA, and each time the process changed slightly. And each time we lost some good elements and added some good elements. And so I think that there's still room to go. There's still a way to go before we absolutely nail the process, to make it as valuable for the contributors, but also to ensure that the outcome is good enough. The way we approached it was, that we were fortunate to have a huge audience that was interested in this. So we took a subset, which was our steering committee, and they kind of guided the process. And then we had the broader audience that we used as a sense checker, and an opportunity to gain, much broader feedback from a broader set of industries and types of lawyers and jurisdictions. So we had a really rich data set, if you like, of input. And then I think the most important part of this process is the iteration bit. So you can't assume that you've nailed it first go. So that's why we have 2 iteration rounds before the first version is launched. And then there's a feedback page that people can give us feedback about how it's performing in reality. So with oneNDA, there were certain bits that always got pushed back on. No one assumed that would be the case when we issued the document. But then through feedback, we found out that banks in particular were pushing back on a specific clause. So in version 2, we amended the document so that it would include an arbitration clause because that's what people wanted. So that's fine. So that was that. I think the iteration piece is really important. The other thing that took ages was the comms. So there was a lot of communicating with different sets of audiences, with different sets of people. The messaging needed to vary slightly. I spoke to 150 lawyers in March alone on Zoom. So it was intense. It was a really intense process. I loved it. I think oneNDA has been the highlight of my career. But I loved it, but it was absolutely exhausting and it's totally unscalable. But that's what you need to do to build a good product. You must do things that are not scalable. So yeah, the process was a lot of influencing and winning hearts and minds and trying to say to people, be pragmatic, no one litigates, it's fine. And then also the logistics of trying to organize 60 lawyers on the steering committee. We had 1,200 people feeding into the document itself, and then a broader audience of 10,000 people. It was a lot, and thank God I've got such an amazing team. Also, everyone's really organised and very quality driven. So we could not have pulled it off if we didn't have such a fantastic team.
Wonderful. Yeah, that sounds like so much work, but like the work put in earlier to make the process of just doing NDAs much, much faster and easier later. So yeah, totally worth it, from my perspective. I'm, the way I always think about, when we talk about changing law, changing the legal industry, I always go back to school because I like to think of it from a more academic perspective, because lawyers are not born, they're created in law schools. And whenever we're thinking about new ways of thinking about law, I think it's also important to somehow find a way to incorporate that into law school curriculums, because unless we do that, it's not really going to be, it's going to be a little bit slower to, create that sort of paradigm shift in the industry. How do you think initiatives like CloudStack, oneNDA, oneDPA, they could be potentially integrated into the way law is taught and the way that students are taught to draft contracts? Do you see it being integrated into school curriculums?
I mean, my vision is that we don't draft anymore; we build. So we've got a set of Lego blocks which are provisions that are agreed. They're pre-agreed standards, and then as a lawyer, instead of being taught how to draft, which by the way I learned none of at university, all I learned was the case law and the regulations and the laws and how it will fit together. We didn't really get any practical experience of how to draft a contract. I didn't know how to review a contract even after I'd finished my training contract. So it is hard to get that practical experience embedded into the education system because it's so far away from the profession in the first place. And then when you get into your training contract or in practice, I think that the thing that's really a huge value add from a lawyer's perspective is the ability to gauge risk and advise on it pragmatically. Is it in drafting really complicated wording to express a certain provision? Does it even need to be bespoke? Maybe, but how often is that the case? So I'm hoping that we'll get to a point where at least the commoditized language is standardized, and then lawyers can focus on maybe drafting that really bespoke clause that needs to be bespoke because it expresses a certain risk or an obligation or a position. And then the rest of the time, we think about how that contract's going to affect the business and advise them accordingly.
Yeah, totally. And apart from NDA and DPA, are there other things in the pipeline at CloudStack? Are there other types of contracts that you're also working on standardizing?
We're not working on standardizing anything else at the moment because our focus is on setting up CloudStack and delivering oneDPA and learning from the process. But as with anything that we do, it will be community driven. So with oneDPA, we didn't decide to do it. The community said that they wanted it. We had a poll asking people to vote on the contracts that they wanted to standardize, and the community, 53% of them said they wanted oneDPA. And so oneDPA it was. So we'll do the same in the future again. But we've got an ideas page on CloudStack, and people drop their ideas on what they think should be standardized. Employment agreements pretty popular. And we've got things like MSA or just terms of service. So that's really popular as well. So yeah, there's room to standardize a lot.
That's amazing. And when you think about, expanding, CloudStack and including more and more agreements like employment, MSA, what is your ultimate dream? What is your vision with CloudStack maybe in the next 5 years? What do you see it accomplishing?
So I see CloudStack as a mixture of GitHub and Stack Overflow for law. So I'd like for more people to standardize and drive their own initiative to standardize documents within their industries. I'm not an employment lawyer. I'm not the right person to drive that initiative. But there are employment lawyers out there that understand that standardization is good for them and their clients, whether those are internal or external. So hopefully we'll create an infrastructure that will encourage more and more organizations to come, or people, individuals, to come and run their own standardization project. And then ultimately, when we've got enough standards, we can have a library of clauses that have been standardized to express certain provisions that you can then have across all your standard agreements. So that's one element. So creating standards within contracts is one vision. And the other is a place where we can just come and collaborate and share knowledge, because it's really hard to share knowledge within the legal industry without paying for it. And in a world where information is mostly free, I don't see how that's sustainable.
Yeah. And I remember from your previous talks, you've also talked about sort of democratizing the way we draft contracts and the way we share knowledge in the legal industry. And I think that's awesome as a young attorney myself. And yet when I graduated from law school, a lot of that sort of knowledge just wasn't as available. It can be very intimidating to ask your senior attorneys to tell you how to draft a basic contract. So I was in a very similar boat as you. Didn't learn a lot of that in law school. So yeah, I particularly appreciate that knowledge sharing mechanism, because it is hard in the legal industry to just find that type of stuff for free. So I really appreciate what you're doing.
Thank you. And yeah, I think it's time for legal knowledge to be open sourced and democratized as much as possible, because in 5 years' time, 75% of the workforce will be millennials. And as millennials, we're used to managing our whole lives on our iPhone, everything, our finances, our love lives, our restaurant choices, everything's managed on our phone. And then you go to work as a lawyer, and, I know some platforms where you still have to use Boolean search characters to get the information that it's not, come on. So we're not going to put up with it. So I think, we Google stuff, and all lawyers Google stuff, but it's just that the information that you get is not reliable. And to get reliable information, you have to pay loads of money for it. So if you're a freelance lawyer or a junior lawyer or a law student without access to all this stuff that's paywalled, it's really hard to get the information. Then when you do get the information, it's of course curated by the people that are broadcasting the information. So I think taking a more democratized approach to knowledge sharing, standards creation, and templates is the way forward, and is the thing that will transform the legal industry at its core.
Absolutely. I cannot agree with you more. That really does resonate with me. I mean, you are talking about, single practitioners or, junior attorneys. What have been the kinds of people that have shown the most interest in oneNDA, oneDP? Has it been law firms? Is it individual practitioners? Is it businesses, or is it sales teams from businesses, or who are these people?
So from the 10,000 people, around 300 were law firms. The rest were businesses. And we had almost an exact equal split between small and medium enterprises, freelancers, individuals and startups, and large corporates. So we have a third, a third, a third. So it works for everybody. And 250 law firms or 300 law firms, however many it were, is a significant number.
Yeah,
Yeah.
indeed. Wow. And lots of it from in-house counsels as well. Like, have you had the opportunity to speak with them and talk about how exactly they've used oneNDA and what their experience has been as well?
Yeah. So with the smaller organizations, they started seeing efficiencies immediately when they started using it. My objective initially was that everyone adopted oneNDA. And so the next time you enter into negotiation, you send over oneNDA and you say, this is my standard. And they say, that's great, because that's also my standard. And what happens is that there's no negotiation and the deal's concluded. But actually what happened was that we didn't have to wait for that. We didn't have to wait for that to happen necessarily in order for oneNDA to be effective, because oneNDA has a brand now, so that if you send it to the other side, they know that it's an industry standard and they just don't negotiate it. So even if they haven't adopted it, they accept it. And this is a question that I've got now that I'm obsessed with, this question that I'm trying to solve. And if anyone's got any ideas, please reach out. How do we measure success? Is it by saying that these companies have adopted it? Is it by saying that these companies accept it? Is it by measuring its actual use, for which we need technology, and to see which bits are contentious or not, and whether there's friction? We're not quite sure how to measure success. For now, what we're doing is we're measuring success based on number of organizations that have adopted it as their own. But I think there's another step there that we're not using, we're not looking at. So anyone with any thoughts, reach out.
Yeah, totally. And I think that's a very, very valid question, because in terms of other changes that have also happened in society through law, we often sort of quantify success with how many organizations or how many people, how many legislations were passed, to make that particular change happen. And I don't think we take or give as much credence to the soft power of different types of movements. I mean, look at like the women's rights at work movement, all those other things. Initially, they were not as successful in integrating themselves into law and becoming a reality directly in the organization's bylaws and stuff. But it had a lot of soft power. It had a transformative change in the ideologies at large companies and the way they treated their female employees. So I think comparing that with LegalTech also and standardization also, it for sure is creating this change in the way people at least are looking at contracts and exploring those sort of possibilities, that if I can standardize that, why do I need to go down the artisanal road? It's just making my life more difficult. So yeah, that's just my perspective. I'm into like the sociology of law, and I hope someone writes a paper about this, the soft power of the legal tech industry. Maybe that could be something I could do as a side project.
Yeah,
or you could do as a white paper or like some sort of a paper on COSTAC, the soft power of standardization. Yeah. It's been wonderful having you as a speaker, Electra. This has been a really great conversation. I really admire all the work that you're doing at COSTAC. When I was in law school, these are the types of things that I would have really, really appreciated, like learning about. And I'm glad to be part of the legal tech industry. And thank you so much for coming and sharing about all your amazing work. And really looking forward to reading the first draft of oneDP. I've been looking forward to it for a while now. It'll be awesome.
Thank you so much. And I really enjoyed that. So thanks.
Great. Awesome. And thanks so much to all our audience for tuning in from different parts of the world. Always appreciate your interest in learning more about legal tech and being a part of transforming the legal industry. And check out CloudStack, check out our work at Speed Legal, and drop your comments on the video that will be later posted on LinkedIn. And please do feel free to reach out with any comments or questions. And thanks again, everyone. I will end the stream now.
Thanks, everyone. Bye.